Still here with us this hour, Bob Bianchi. Bob, of course, this guy is, again, paramount to this entire case. We heard him there testify that on that day, Lindsay was having one of her best days, that day on January 24th when this all went down. Bob, do you think that's a significant statement for the prosecution's theory that she knew what she was doing? I mean, she was, from all accounts of him, he said she was in her right mind.
Well, don't know. I'll say this. He's truthful, and he also supports the idea that she did this because of her mental health illness, improper diagnosis, and medication. So as a defense lawyer, I'm going to use this to say, here's a guy who's clearly not lying just to try to get his wife out of something. He could have said something completely different. No, she was completely freaky. And that she had some sort of psychotic break, which I expect is what the defense testimony is going to be. Reminds me of, some people that I know that have committed, unalived themselves, as they say today, where you're just like, oh my God, I was just talking to them yesterday, or I just saw them an hour ago, and you would never have known it. So I suspect that's where we're going to go. Last point here, Cody, it's just like, I look at this guy, and in all the years where we kid around, and say you've seen everything.
Here we go.
No,
here it goes.
I've never seen anything like this.
Yeah.
Right? Everything the man loved was destroyed. I can't even. I mean, I've seen a lot of trauma and death, but this guy lost his wife and his 3 beautiful babies,
his whole family,
to this mental illness or whatever. It's sad,
and it is a sad situation, Bob. But one of the things I keep coming back to, though, it's just he's talking about he never saw Lindsay harm these children before that day, January 24th. It may be an important fact for the defense, maybe, but I still come back to the fact that this only happened. All of this happened when he was away from the home, right? It kind of reinforced the idea that she knew what she was doing was bad. She recognized it was not the most ideal thing to do. She didn't want him to see it to try to stop it or intervene or do anything else until maybe after she was dead, which we know she was unsuccessful in that attempt, jumping out that second-story window. But under no other circumstance did she harm these children with him inside the home. Because, I'm sure a juror is going to be wrestling with that. Like, if she was really going through this psychotic break, how did it conveniently only happen when he wasn't there?
Yeah, so when we're talking about not guilty by reason of insanity, you have a couple of ingredients to bake the cake. And one ingredient is that she has a documented, established DSM-5 illness, which she's got, okay? That she was suffering from that. And that as a result of that, she wasn't able to form an intent to commit a criminal act because of one of 2 things. It doesn't have to be both, just one of 2. That she didn't know the difference between right or wrong. That gets to your point right here. She's waiting for him to leave. He's saying she's doing okay. But the second element that I suspect the defense is going to concentrate on more is that mental illness prevented her from being able to conform her conduct lawfully. That's the second prong that's there. So you can know what you're doing is wrong, but you just are compelled because of the illness to do it anyway.
I'm sure we're going to hear about all of that through expert testimony from both sides as the trial continues. And, Bob, as I continue to, I know it's only been one day, but as we research and we talk about this case, walking the line of mental health here, it seems like it might be one of those cases that ends up being or shaping up to be kind of a credibility battle. Not, necessarily between the expert testimony, which I'm sure it'll be some of that, the elements of that too, but maybe credibility between Patrick and whatever other family members they decide to call if they do, and these experts. Because while they are experts, they are not in the house. They're not experiencing this woman every single day. This man was in the house every day, has gone through, 3 childbirths with her, was married with her, saw the behavior, saw the mental decline, according to him. To me, I mean, if I was on a jury, though you'll be wrestling, torn between all these different things and every different direction your mind is going to be pulled, but I'd rather take his word from a man who was in the house with her than the word of somebody who might be saying some factual stuff, but they still weren't there with her every day.
This is a battle that lawyers have all the time when they try cases. I am in your league. I believe in common sense. The people that were dealing with her, the context of the individual, those people who can validate, because experts can be on both sides, and then the jury doesn't understand the DSM-5 and this test and that test and the other. It's what the lived experience from a credible witness is going to be more powerful. I'll tell you another thing I think is going to be powerful in the case, Cody, is her demeanor in the courtroom. And we've often talked about, like, how should you appear? And it's very hard to tell a defendant how to appear or not appear. But you know what? Jurors can see anger and they can see duplicitousness. It's hard to explain. We communicate far more with our body language and things of that nature. And so far, she has been in this zoned out kind of catatonic-like state, and I think that is going to be impactful too.
Absolutely. They'll of course be looking at all of that, the expressions, whether she raises her eyes or whether she seems somber when the children are talked about or what have you. I'm sure they'll be looking at all those little minute details that may otherwise go unnoticed. Watch along with us, Bob Bianchi. Bob, you've been in more situations like this than me in those courtrooms. How important are opening statements in a case like this with an insanity defense where both sides agree that this defendant did this thing, but they both starkly disagree on why it happened?
Yeah, well, when young lawyers come out of law school, they can't wait for that great closing argument, the fire and brimstone, bring it home kind of thing. That's not the most important part of the trial. It's the most important part of planning a trial. You start with your summation in your head and then what you want to say, and then you back your way into it along the way of preparation in order to do the building blocks and pieces of evidence and witness statements in order to be able to say those things at the end. But in truth, at a trial, the most important part is the opening statement. That is what is going to form the jury's impression and give them the roadmap so that when the evidence is coming in piecemeal and sometimes out of timing, they're able to place the evidence into what it was, that container that you gave them in the opening statement. And so those who win the jury in the opening statement typically are going to win the case at the end. And may I say, at the end, this opening statement with her talking about, all these particulars and very fastidiousness and so on and so forth, maybe that's mental illness.
Yeah, well, fair point. Fair point. And as we always talk about, primacy and recency, and this is the primacy leading it off. Let's take a listen to a little bit more openings from the defense and prosecution here, Bob. Still with us this hour, Bob Bianchi. And Bob, before we get into it here, let's take a look at the jury view motion document that was filed by the court here. I'll read some of it to you. On January 24th, 2023, it is alleged that the defendant brought each of her children to the basement of their home where she then strangled each one with an exercise band before going to her bedroom with a knife and attempting to cut her wrists and neck. The defendant then exited from the second floor bedroom window and landed on the hard frozen ground where her husband and first responders found her. Inspection of the inside and outside of the home will assist the jury in understanding the evidence and events of that night. Bob, how valuable will this jury view here be to this case? Because initially, I know there was, arguments about it pre-trial. I was thinking, it's not like going to see, the house, O.J. Simpson's house. It's not like going to see the dog kennels in the Murdaugh case or something like that. We know this happened in the house. We know the second floor window and all of that. I was of the mind, like, why is this super necessary? But then, of course, all the locations, I'm sure, the time and distance stuff will factor in here. Do you think this jury view is super necessary?
Evidence Rule 403 states that a judge can preclude evidence, even relevant evidence, if it's an undue consumption of time or confusion of facts to the jury, or is not the probative value, it doesn't outweigh its prejudicial effect. The reason why we used to not want to do this is because we can't account that all the jurors are going to see the same thing. It's an uncontrolled environment. And to your point, if there is something specifically that you can point to that you say we can't document by way of a photo or a video or through testimony, and only if the jurors were to see it would they be able to fully be able to appreciate this particular fact, then the courts typically would allow that, but they were very cautious and judicious about doing that. It seems like it's happening with more and more frequency now that they're allowing this. I don't get it. If I were a judge, I would not allow it. I would think that I can't contain what 12 jurors see, and now they're in the jury room potentially, because they're not discussing the case until they get the case at the end of everything.
Yeah.
And one saying, didn't you see that red thing? No, didn't you see that? But no, it was green. Now they're all arguing about what it was they may have seen, and they can't go back to the scene to correct their misrecollection or, to get the right recollection. So it's wrought with some danger to it. I wouldn't allow it as a judge in this particular case, but I'm not sitting there listening, and I'm clearly don't have black robes on.
Exactly. I mean, I get it. That's the thing I say about myself sitting here. I'm just a TV boy sitting at this desk. But the thing about it, Bob, to your point, I mean, especially when you start, you go into the three different locations. Of course, important facts of the case, because, there's that whole allegation that she sent him off, she was timing everything out. But, I mean, what if it's like, well, between the 3V restaurant and the CVS, I only felt like it was like 7 minutes. Another one might have been, well, it might have been 4 minutes. It might have been 12. All of that different stuff. Well, she wouldn't have had enough time. You see how, listen, there's too much at play here. But on that same token, Bob, as far as the distance stuff, the prosecution obviously says that Lindsay sent him out and did plan around that distance and the timing of it all. I mean, how important is that going to be for their case in attempting to prove some form of premeditation here? I mean, I feel like that's arguably their whole case.
I don't think it's important at all. And to be honest with you, if I were the defense lawyer in the case, I would be sitting there and saying, look at all the tricks and dog and pony show that went on here. Was it really relevant that the prosecutors brought you to this home? Is that going to change they want to bring you there because they want you to feel it. They want you to be emotional. The judge is going to tell you that you're not supposed to use emotion, sympathy, bias, or prejudice. But that's exactly what they tried to do. And then there's a stupid thing about how long it took him to get from here to there. Look, we know she killed her kids. That's a fact. Yeah. This is all because they didn't have a good case that they're trying to throw all these different things at you because they're trying to get you in your heart where they couldn't get you from the law and facts of the case. That's how I'd argue it as a defense lawyer. Yeah,
you got to separate that emotion and what really went down here. Does it really matter how long it took? You still got three dead children here. Bob, I mean, again, that's what I was bringing up in one of the previous segments. I mean, what we have at hand here, and look at these three beautiful kids. You had a 5-year-old, a 3-year-old, and an 8-month-old. With an exercise band tied around their necks. This father's coming home for what he thought was going to be just any old other day, going to get dinner for his family, and now he comes back home and he's lost everything. His kids are dead. His wife's in the backyard, paralyzed, can't move. To your point, I feel like that is the only what they're hoping to gain from this jury view is that emotional tug here.
Yeah, Cody, I just want to say one thing. I think that is important for your audience. What's also missing here? I just thought about it. And the defense, I think, is a big hole in the prosecution's case. In a lot of murder cases, even though you don't need motive to win a murder case, what otherwise is this nurse who's works with children, who's by all accounts this perfect mother, who has this significant mental health issue and mental health medication? What's her motive to do this? If they can't provide a motive, like one day she just woke up and said, hey, I think it's a good idea to kill my kids because of what? Money? No. Infidelity? No. You list off a couple of them. It can only be one explanation left as to why somebody would do that. Horrible, tragic thing, and that's mental illness.
Absolutely.
I think look, if I had to be the choice between a prosecutor or a defense lawyer, if you told me, and winning is something I like to do, I'm picking the defense for this case.
I mean, I couldn't agree more here, Bob. I mean, when you point these things out, is why I always, look up to what you have to say, and I enjoy having you on because you give me a different perspective when we talk about all these different cases. And that is a very fair point because why else? You had no record of this before, and now all of a sudden, there's nothing about getting back at Patrick. There's nothing about financial gain. It had to be something that wasn't firing off right here in the space between her ears there. Bob, my friend, stand by.